Hello, my name is Paul Downs. I'm a barrister at Quadrant Chambers. I've been practicing in banking law and international trade for 30 years, and this QBiT talk is called What is Strict Compliance? This is in the context of letters of credit and performance bonds, and I'm going to tell you everything you need to know about the doctrine of strict compliance in 10 minutes. Now, as you probably know, a letter of credit is a means by which parties to a contract for the sale of goods can trade through the banking system in documents. In other words, instead of trading goods for money, you trade documents for money, with the guarantee of a banker's word behind the instrument in question. The documents, typically three sorts of documents you have. You have a document of title, like a bill of lading. You have an inspection certificate, confirming that the goods were in good condition when they were put on the vessel. And thirdly, some sort of insurance certificate. You can have all sorts of documents. Now, the buyer gets the bank to issue the letter of credit, and the bank says to the seller that if you present these documents, I guarantee I will pay. And it's that guarantee that gives the letter of credit its integrity. But the important point is the documents have to be exactly as the buyer stipulates. So, for example, if you had 100 kilograms of cheese on the letter of credit, but the bill of lading says that it's 100 grams of cheese, obviously there's going to be a problem. Now, there's a lot of cases, as you can probably imagine, about this doctrine. One old case I really like is the case of Equitable Trust versus Dawson. There was a consignment of vanilla beans coming from Batavia in the Dutch East Indies, going to Dawson and Partners. They were an importer operating in London. And the buyers said they wanted a certificate of inspection by the Dutch government. And the seller contacted the buyers and the bank and said, look, we've got a problem. The Dutch government doesn't issue a certificate of inspection, but we found this very reputable local inspectorate and they will issue a certificate in its place. It all turned out to be a complete fraud, and the issue was whether the certificate of inspection that was presented to the bank was compliant with the letter of credit. And the answer was no. And very famous words of Viscount Sumner, he said, there is no room for documents which are almost the same or which will do just as well. Business could not proceed securely on any other lines. Now, it sounds very straightforward, but in fact, there are a number of problems with this doctrine in practice. And there are three of them I'm going to talk about very briefly. Firstly, typographical errors. Secondly, what are original documents? And thirdly, what is the bank taken to know? So, just thinking about typographical errors. Now, there is some guidance from the ICC, which are the sort of governing body looking after these documents. And they say there are a lot of situations where slight errors in spelling won't make a difference. So, for example, if the merchandise is described as a machine, M-A-S-H-I-N-E, instead of a machine, M-A-C-H-I-N-E, that's fine. Or fountain pen, T-A-N pen, is fine if that's referring to a fountain pen, T-A-I-N. Model, M-O-D-L-E, instead of model, M-O-D-L-E-L, is fine, but other differences won't suffice. So, for example, model 123 would not be good enough if the letter of credit stipulated model 321. So far, so straightforward, but the cases are not always easy to reconcile with each other. So, for example, there was a case called United Bank versus Banque Nationale de Paris, and the letter of credit referred to a party as Pan Associated Limited. And when the documents came in, they said Pan Associated PTE Limited, held by the courts, not compliant. But in a later case, Credit Bank and Midland Bank, the letter of credit required a draft survey by Griffith Inspectorate, but the documents, the certificate of inspection was a survey signed by C. Griffith Holland BV, held compliant. Now, that's where there's a typo in the documents, but what about where there's a typographical error in the letter of credit itself? So, for example, the letter of credit says the address of the consignee is 10 Fleet Street, London. But the documents, when they're presented, have the correct address, 10 Fleet Street, London. There's no case law on this, but my practical advice in that situation is if you can, reissue the document with the misspelt address, but with a covering letter explaining the problem. But that's not always possible. It's probably going to be okay, provided the error is obvious, and provided you can construe the letter of credit by reference to other surrounding documents to point out the error on its face. Another area of difficulty is where originals are concerned. The rule is that if the letter of credit requires original documents, then the presenter has to present original documents. But what are original documents? What if they're produced by a laser printer? The ICC rules say that a document produced by reprographic means must be marked original with a stamp. So in Glencore versus Bank of China, there was a document produced on a high quality photocopier which was signed, but it wasn't stamped, held not compliant. But then in the Credit Bank and Midland Bank case that we talked about, there was an insurance certificate produced on a high quality laser printer, and Lord Justice Evans said a document which clearly is the original in the sense that it contains the relevant contract and which is not itself a copy of some other document is certainly an original for the purposes of the underlying rule. So in other words, if it is an original and it's not a copy, it definitely is an original. Not perhaps terribly helpful. The third issue that sometimes comes up is to what extent is the banker required to look something up or to do a little bit of research? The general rule is that the banker is only required to look at the documents on their face. So let's take an example. The letter of credit says the goods are to be delivered to Fleet Street, London, but the documents say Fleet Street, London, London spelled L-O-N-D-A-N. Well, you might say that's an obvious error. But what is the banker supposed to do? How does the banker know that there isn't another Fleet Street in a different town called London? Is he required to look on Google Maps and see or search? There's no clear answer to that, but the answer is, generally speaking, the banker is not required to do anything other than look at the documents and see whether on their face they comply. So that's it. Everything you need to know about the doctrine of strict compliance in 10 minutes. Thanks for watching.